Okay, good afternoon, everybody. We have a number of items that we're going to hear today, and this is a committee day in the midst of a very busy legislative week. We have people going and coming. Out of an interest of fairness, we got people online. What I'm going to do today to give everybody the opportunity is I'm going to have us to have the presentations on these bills. And we'll do the presentations on all the bills, and then we will get to, if the committee wishes to action, I'll come back around to them, and we'll do the voting. If the committee wishes to take action on any of the measures, we'll do that at the end to give everybody the opportunity. Otherwise, we have people that need to be places, and we have them running back and forth in order to try to get to a vote. So I think to allow our members the opportunity to participate in voting on the measures, we'll put the votes together. You know, if the committee wishes to move on the items at the end of the meeting. And I'm going to say, for everybody's planning purposes, I don't see that'll be before 1:30. For those that are online, those are with us online, but maybe in other parts of the Capitol, please try to be settled online where we can take actions, or be with us in Capitol 341. Okay, we're going to get going this morning. I guess it's morning someplace. We're going to get going this afternoon. The first item, or the first measure, we're going to go down in numerical order. I'm going to have Representative Bonner. We're going to let you present from the back, if I can find your I'm going to wireless mic is what we're going to have. We have House Bill 1. If you could tell us what we have that might be different than what we saw the last time we were here. Representative, I think you just have, Chairman, you just have to lean in. Governor's floor
there
leader.
he goes. I had to turn it on, which is good. Okay. Thank you, Mr. Chairman, members of the committee. So I believe this is the third time that I've come before you with this bill, and we've certainly made some changes to it. Most significantly, what we did was to
if you would put us on the LC number that you think we're talking to.
So I'm referencing LC 490477S.
Everyone all the members have a copy of that? If you don't, that should have been what you were emailed if you're with us virtually. If there's an issue with that, let us know. Please carry on, sir.
Thank you, Mr. Chairman. So what we did, there was one of the primary concerns raised by members of the committee was in regards to the association piece of the bill. And so we did try to work through some things with USG and members of the committee, and just weren't getting there, so we just decided to delete that portion. Then we went back and just scrubbed the language that was in House Bill 995 that was passed out of this committee last session, and we adjusted some of the definitions to in fact match that. So in addition to removing that association piece, we went in and made sure that the definition of student-on-student harassment was exactly the same as it was in 995. We also did the same with the portion that on what is now line 78 of the bill in regards to protected express activity. And we made sure that was consistent on both in both areas of the universities and technical colleges. And so the only thing that is actually not substantially different, or there's a slightly different from House Bill 995 in terms of definition, is what appears on line 34 of your document, and that's the materially and substantially disrupts definition. And again, as we discussed before, that particular definition, that wording comes straight out of case law. So we made a number of adjustments to not only bring it in line with House Bill 995 that was passed out, but we also deleted that portion that addresses the association piece for our universities. So subject to that, Mr. Chairman, I'll be happy to answer any questions.
Questions. I'm flying without a net here. Number 1, is that you? Yes, ma'am.
Thank you, Mr. Chair, and thank you, Representative Bonner, for addressing some of the concerns that I had previously when it came to definitions and matching what we had when we amended HB 995 and this current bill, HB 1. You mentioned that you did not necessarily feel it was necessary to change the definition of materially and substantially disrupts. I just have a question for you. Do you have any concerns? Are you worried that the current definition, as it is written in this particular LC number, could limit counter protesting, since the intention to disrupt you only have to intentionally engage in a certain conduct, but you don't actually have to be causing any type of harm in that particular situation?
I'm sorry, could you maybe clarify that a little bit?
Yeah, so what I'm asking is, I'll be clear, does this definition limit counter protesting in any way?
It does not. It does not limit counter protesting. Again, the kind of the default on this is that nothing in this bill allows for any illegal activity. So at whatever point either side of a particular debate starts entering into that area that is illegal, then the university has the right and obligation to step in and prevent that.
Thank you.
Further questions, in person or online? I'm going to let you help me monitor.
Mr. Chairman, this is Representative Bentley. I have a question.
It's this Representative Bentley?
Right, Representative Bentley.
Yep.
Can you hear me well? I have a question. I'm online. I'm driving.
Yes, ma'am. Go ahead.
I just want to know, to the author of the bill, with the changes that he made, is the university system in support of those changes? I knew previously I think there were still some concerns maybe from the university system or someone affiliated with the university system. Can he speak to that, please?
Sure. I think we've gotten the university system to neutral on this. I mean, even with 995, they took the position that they did not feel that the bill itself was needed, but we did again match the wording exactly to what their input was previously. So I wouldn't say that they're enthusiastically for it, but I think that this is what they can live with.
Yeah, and to the Secretary of the Committee, we have a representative from the USG. If the committee would like, I can ask her to share information. I can say this, that materially and substantially, the definition was changed. This is not exactly the definition that the author of the bill wanted. We had feedback from the university system. We had feedback from folks in legislative council, and we do feel like this is a good balance on that definition. So this is something, if the committee would like, I would ask Ms. Bowen to weigh in, and I'd do that at this time if Ms. Brooke Bowen.
Yes, sir. I would like so. Thank you, Mr. Chairman.
We're going to give her the floor. Yes, ma'am. Ms. Bowen, can you unmute? And there you are.
Thank you, Chairman Martin. Thank you, Representative Bonner. Yes, I'd say Representative Bonner adequately described our position. We still believe that there are adequate protections in federal and state law, but with the changes that have been made to the bill and with the bill that is currently drafted, we do believe that we can work with this bill going forward.
Thank you very much. And again, I'm going to have to go here with numbers here. Number 16, somewhere over here. Is that you, Representative? You have, yes.
Thank you, Mr. Chairman. To Ms. Bowen, I just wanted to confirm that y'all are not concerned of any unintended consequences with these definitions or if this bill moved forward. Is that correct?
Ms. Bowen, did you hear the question? You're still, there you go.
I did. I would just say, again, just to restate our position, that We believe that the bill is currently drafted. We will be able to work with that with our institutions. We still don't think it's needed. I do appreciate Representative Bonner and Chairman Martin that this has been, there's been a lot of compromise to get to this current bill, and I do believe we can work with this bill, and that with the bill as currently drafted, we wouldn't be subject to potentially violating other laws.
Thank you.
Are there further questions with the committee, either in person or online? Representative, yes, ma'am.
Thank you, Mr. Chair. I just have a question for Mrs. Bowen. Would this bill in the form it's written now make it possible or make it easier or more difficult for the University System of Georgia to dissolve conflicts within the system, or would it force you to go outside the system? Could you elaborate on this a bit more so that I understand for this version of the bill?
I'd say with this version of the bill as it's currently drafted, we feel confident in our current practices around free speech and the First Amendment with our trainings that are currently in place, with our policies in place. I would be hopeful that this current version of the bill would just solidify those policies in place and that we could move forward.
Further questions? Further questions? I see none. Thank you, Representative. We're going to ask you to hang with us here, and we're going to move on to the next measure and have a presentation. At this point, I'm just going in numerical order. House Bill 7. Representative Scott, will you take a spot at the back? Same. And while she's arriving, I would let the members know that this is a bill that we've had before. This is the same language that we've had, and I think the representative knows that there's some work being done in the Senate that's parallel to at least working with the definition of foster children in the system. But if the committee, I'm going to let her. Basically, Representative, you don't have to tell us about it since nothing changed, but just remind, very briefly what the bill does relative to helping out those in the foster system and those that find themselves under the definition of homeless, not able to, prove in-state residency. You can do that at this time. Representative Scott.
Okay, thank you. Thank you, Mr. Chair. Okay, House Bill 7, it just updates the code to make sure that the current and former foster and homeless youth living in Georgia can qualify for in-state tuition in the university system and the technical system. It provides, once that the child is certified that they're from a foster care or homeless situation, that their status is maintained until they graduate, eliminating the need to recertify each year, which can be very difficult, we all know. And it provides that in the foster care system, a student receipt from the state will not be considered income for the purpose of determining their financial need. That is the basis of the bill.
Thank you, Representative. Are there questions? Is that you? Yes, ma'am. The Vice Chair of the committee.
Okay. Thank you, Representative Scott. I did have a chance to sort of review the bill and kind of go through it piece by piece in the past couple of days. I do appreciate the attention of the bill, and I like the language in terms of the foster care children and the language there. I had a question for you in beginning on page 3 about the homeless. Line 55 has evidence, so I believe the following sections here, beginning on line 57, you detail out the list of professionals that can provide evidence of homelessness. So beginning on line 55, has evidence of such status as provided for in this subparagraph. If you look up above, how they define it is currently lacks or during the previous academic year lacked a fixed, regular, or adequate nighttime residence. And then you, beginning on line 57, I believe you detail the list of professionals who would, I guess, provide testimony or evidence, documentation of some sort as to to verify that that individual is indeed homeless. On line 57, I a local educational agency, homeless liaison, I see that. Beginning on line 60, the director or designee of the director of an emergency or transitional shelter. Again, I understand that. Line 63, the director or designee or the director of a program funded as part of Title IV of the Social Security Act. I get that. Where I have a question, if you come on over to the next page, page 4, you see line 66, the state or tribal organization. My concern is with lines 69 and 70. Staff of a university accredited under the laws of the state, or on line 70, such other similar professional. I have a question for you about that, just only in the sense that I'm trying to figure out who those people are, given that I'm concerned here, and I hate to be a negative Nelly on this, but the possibility that there could be individuals perhaps with less than honorable purposes wanting to achieve in-state tuition. Is that creating a hole there that essentially you could drive a truck through? Let's say, for example, an individual who's out of state looking to achieve, anybody wanting to achieve in-state tuition who is not homeless would simply have to find someone that would, I guess, testify to their homelessness. And who would that be? That seems like a very broad swath of individuals there. The first 4 entities are really organizations, which I would assume have some sort of mechanism in place for verifying that indeed that individual is homeless. Either they've been receiving services, there is some sort of a paper trail perhaps. So those first 4 sets of people, I could see how that they're almost, I guess I should say, credentialed officials. I'm just concerned about these last 2, staff of a university.
Okay, let me say that this bill once had a resolution to go with it, and I think all of the university systems and technical colleges here in the state of Georgia, they have a homeless, they have a liaison that is stationed on the campuses that for kids that are homeless or come from foster care. They have a homeless liaison that they put on the campuses to assist and help these students once they get onto the campuses. So, so for the staff of a university, I think that will cover that part of your question. They have someone that works with these kids to help identify who they are.
And if you don't, excuse me for interrupting, but does that mean it doesn't necessarily clarify that that is a homeless liaison, working with that? It just says staff of a university. I mean, that could be anything, couldn't it? That could be anyone?
Well, again, I know that the universities, that they do have a staff that they have set aside that deal directly with the homeless and foster care kids at the university systems here in the state of Georgia and at the technical schools. But even though the language doesn't say it, but they do have them on the college campus.
Right. I'm wondering if perhaps it would be possible to clarify that. And you're referring to line 69. Line 70 seems to be an even broader swath of sort of undefined individuals.
Okay, if you read the definition down below where it says that a student from a homeless situation shall not mean an individual who is for any period within the last 12 consecutive months has been incarcerated in a correctional institution, detention center, jail, similar facility, after having been convicted of a crime, that they would have that right. It's just for the homeless kids that have been maintained in the school system here in the state of Georgia, and they could be verified for those last 12 months that they was definitely indeed a student.
I understand. I just can't help but wonder if line 69 and 70 could be tightened up a bit.
Okay.
If the chair may just say, I'm going to ask Michael Walker. Mr. Walker, are you with us? I see you online.
Can you hear me, Mr. Chairman?
Yes, sir. Can you help us with this? As I read this, tell me if I'm correct. Reading the bill starting on line 44, we have an or between A and B, or I'm sorry, between A and the little I and I don't know how you say that, two little I's. So you have an or
that's
between,
subdivision 2.
but you have an or between the text on 45 and 46 and 47, 48. But then the paragraphs A, B, and C are all and, correct?
Correct.
So does the information in paragraph B allay some of Representative Earhart's concerns relative to somebody trying to game the system? Can you, in brief, hit the highlights of what's contained in 51 through 43? Because one would have to do that and the lines in 55 through 70 that the lady is speaking to, correct?
Yeah, so, yeah, there are lots of divisions in this particular definition. So just maybe a little bit of a primer. Subdivisions 1 and 2 under subparagraph A are together. So those are the optional. So under A, you have to do either 1 or 2. So that's kind of self-contained there. And that's line 45 through 49. Then the and kicks in to say that you have to do A and B. B starts on line 50. And you have to do all of the options under B. So you have to be under 24, you have to currently lack, so on, and you have to have evidence of such status. And then it goes on under that subdivision 3, starting on line 55, it gives options on how you can prove your homeless status. So the meat of the definition, in my opinion, or the primary substance of the definition would be there contained in subparagraph B, lines 50 through 53 effectively. And then subdivision 3 is really just the different mechanisms by which you can verify your homeless status pursuant to that operative definition there in lines 50 through 53. Does that address your question, Mr. Chairman?
I believe so. So the most restrictive, if you will, the most controlling portion is under what you're referring to, lines 50 through 53, am I saying that right? Subparagraph B?
Correct.
And then 55 through 70 is how one would prove that one fit in under subparagraph B, correct?
Correct.
Does that help the ladies? I will turn you back on, yeah. Because without B, I understand the lady's point of, without the lines,
Right.
in, what'd you say, subpart 2, without the lines in subpart 2, subpart 3 is a bit vague. But
Right.
given that subpart 3 is just the proof of subpart 2, I think you've raised a great point, and he's been able to let us know that. Does that make sense?
I think so. I guess what I'm trying to understand, and if I could just clarify this so that I
Sure.
understand, in that section 2, beginning on line 51, currently lacks or during the previous academic year lacked a regular, fixed, adequate nighttime residence as described in that. So that is I'm trying to understand how that evidence is. In other words, is this a subjective measure? This is do these individuals, these professionals that are listed here, they're using the McKinney-Vento Homeless Assistance Act as a guide for that determination? I guess I'm just trying to figure out who these other such professionals are that are going to be making this determination to grant this in-state tuition to individuals.
Fair enough. Now, just to repeat that, Mr. Walker, in case you couldn't hear it as well as we could in the room, the question then becomes, okay, so you have to meet that standard in subpart 2, and you do that by your proof in subpart 3, and the lady's question then goes to, are you comfortable with the other such other similar professional not being able to be used as, your random neighbor or a random person on the street, but someone that would I mean, I don't know if it's I don't know if it's an affidavit.
And if, yeah, that would be my question,
so
are
I
these
think
other people?
That's what the lady's question is when we have a list of people, or at least list of individuals that can do this. When you get down to line 70, other similar professional, is that a term of art in the legal profession that the universities, we feel good about them managing that process? And if we have,
yeah, I understand the question. Thank you, Mr. Chairman. And I won't presume to speak for the author, but I would, I guess my view of this would be that McKinney-Vento in federal law does by and large establish what I think is becoming the standard for defining homeless people, homeless students. And so given the nature of that legal status, I think that this other such similar person language is an effort to recognize that there could be some outlier circumstances where the other ways to verify the status in these parts 1 through 5, the Roman numerals 1 through 5 on 57 through 69, that just may not be possible under the circumstances of a particular child. If there was a need to perhaps tighten this up, I'm kind of quickly scanning through the bill, and I don't see where there is any authorization provided by the General Assembly to, whether it be the Board of Regents or individual units of the university system or the technical college system, to develop rules that could provide some definition as to what standard they would use, or as I think one of the members may have suggested, the use of some type of affidavit or other kind of a little bit more of a formalized verification that could be relied upon in making that determination. But I would defer to the author on that, of course.
Let me, if the lady doesn't ask, does Ms. Bowen, I don't know that this is your sweet spot at the university, so to speak, but is anything you care to add? And if we're asking you out of your area of expertise, Phil, you may politely decline, or even impolitely decline.
I would. This is very much out of my area of expertise. I do believe E.C. Tanner from our office is in the hearing room at this moment. I'm not sure if she has anything to add. I apologize, Chairman Martin.
Thank you very much. We will put her on the spot. If you don't mind, Representative Scott, let Ms. Tanner share the microphone with you there, and she might be able to do this. I would also say that as we're moving forward here, that we are running low on time, and if that is an issue that we need to work on with an affidavit, if that's what's left in this, if the committee decides to move this forward, it would go to rules. I am a member of rules, and I would work with the lady to get that language dropped in and give her a chance to come out of rules, because we have had it for a while. But maybe Ms. Tanner can help us with that.
Mr. Chairman, I'm Kasey Altman with the university system. Thank you for the questions.
My apologies. I knew you as Kasey Tanner, not Kasey Altman.
Not at all. Thank you, Mr. Chairman. I did hear the question. So we're asking about our professionals on campus that would work with the populations outlined in the bill. Is that correct?
Exactly. I think it's staff of a university accredited under the laws or a similar individual. I guess the question that the Vice Chair of the committee, Representative Earhart, makes is, do we feel good about, for this to be certified and come into the university system, that it would be an individual that would have a professional reputation, if you will, to put on the line? That it would not be somebody that would be doing it for someone just to get them in-state tuition. This would be someone that was, unique, qualified under this definition.
Right. No, thank you for that. That certainly makes sense. I do not know who those professionals are on every one of our university campuses. We can certainly get that information from our institutions that are within the university system. I do know from my experience on campuses, we do have folks, as the bill sponsor mentioned, that work with these type of students who maybe are in need of different services that some of our other student populations might not be. But like I said, we'll be glad if the committee would like us to get a list of those professionals who are on our campuses today.
Thank you very much. Depending on the action of the committee later in the day, I will call upon you, if this does move forward to rules, to help you engage those folks from the university system and our friends with TCSG to make sure that we have the appropriate check-in so that we take care of what the bill's meant to do and not leave room for misuse. So if we are getting to that position. Thank you very much.
Glad to do that. Thank you.
We did have another couple of questions. Dr. Clark.
Thank you, Mr. Chair, and I just wanted to thank the author of this bill for bringing this bill, because I think it is very important that we increase opportunities for all of our students across the state to, enhance their education. And so I think this is an amazing bill, and thank you so much for bringing the bill, and I don't actually have a question. Thank you.
Thank you, Mr. Chairman. I did have a question, and I just wanted to clarify. The bill does provide for an objective standard to determine homelessness, through which various individuals would then be able to provide further evidence that that objective standard has been met. And is it not true that ultimately it would be USG to make the determination as to whether or not a student is qualified for in-state versus out-of-state tuition? And I think they would have that ability. And this bill, which would be my understanding, is it not true that it would simply provide USG an additional opportunity to provide in-state tuition based on these objective standards through which various individuals may be able to provide proof?
I believe that's the lady's intent. I think that's fair to say. We have virtually with us the Dean of the Georgia House, Representative Smyrie.
I just wanted to weigh in, Mr. Chairman. I think this fits well in what we're trying to get done in dealing with the homelessness. And I can tell you, I remember the McKinney V2 Act back in the 80s, and I agree with our legal counsel might have said it's the gold standard on the measures. One of the first homeless acts that Congress passed, and I remember it being an issue. And I remember that President Reagan signed it, and it was a step in the right direction. It was a major step in the right direction in dealing with our homelessness, and as it relates to going to these universities and be residents in them and that sort of thing. So I did want to follow up with the legal counsel and let you know that is a major component with that McKinley V2 Act and back in the 80s, and so I think it's something that we can work out. I sure would like to see that, because I think this is a good piece of legislation.
I'm sorry. Thank you, Representative. I see no more questions. I'm going to sound something for the committee to consider if you guys want to jot this down. Mr. Walker suggested this as a potential amendment if we come back to this bill, or when we come back to this bill later, that we might consider an amendment that inserts after the word professional on line 70, the text, comma, as deemed appropriate by the post-secondary educational institution. That would give the university system a bit, or the technical college system, and since this bill is drafted where the TCSG uses the definitions from the university system, we'd only need to do that in that one place. But that would just be something for some to consider as we come back to the bill. And Representative Scott, I don't believe that hurts your proposition at all. I believe that might help us out. Are there any further questions online or in person? All right, thank you, Representative. If you'll hang around with us, we're going to keep moving. Next, Representative Carpenter, HB 120. And I think I think the representative has some, he is a member of this committee in addition to being the author of the bill. I think he has some items he would like to talk to us about the bill, but I want to be clear, we are starting with the 120, HB 120 that was distributed last Wednesday, over a week ago, LC 490461S. Am I correct?
Yes,
Okay.
sir. Thank you, Chairman.
Representative Carpenter.
Thank you very much, Chairman. Thank you, committee. So this is the bill you've heard. I'm glad to finally be presenting it in person this year. Just a couple of changes that I would like to discuss with the committee more than anything. Everything else is pretty much what you heard last week, which I'm perfectly fine with. Thanks to the chairman for working with me. My only concern is on line 46, where it says the opportunity tuition shall not be less than 100% of such units. I'm perfectly fine with the making sure that these individuals are paying at least what in-state folks are paying, but I would like to put a cap on the top side of that, tuition factor, and make it from 100 to 110%. So that way, because currently as it reads now, if the university system so chose, they could just charge them regular out-of-state tuition rates. There's also another piece under the technical college system as well. I think that's around line 103, 104. We would basically say shall not be less than 100% or not more than 110% of in-state tuition. And other than that, I'm perfectly fine with the language this committee was presented last week, and I apologize for not being there, and I'll be glad to take any questions on the matter.
Thank you, Mr. Chairman. Representative Carpenter, regarding the change that you would like to make beginning on line 46, approximately what is the out-of-state tuition as a percentage of the in-state tuition?
It varies for each institution, but for instance, Dalton State currently is $5,000 versus $17,000. So it's 3.5 times as much. So I think if we leave that, go ahead. I'm sorry.
No, to be clear, that's for 2 semesters, right? That's a year.
Yeah, I think so. Yes, sir.
So in this, one of the things I was thinking about with this section, which is number 6, 43 through 47 lines, what I was thinking was if institutions would like to use the Delta jet analogy we've used before, if you have 25 seats on a plane, you want to get that plane filled up and you drop the rate. But if you have 3 seats left in the plane, then you're not going to drop it to the same extent that you would if the plane is only a quarter full. And so I was thinking that so if you went with a cap, my preference would be that the cap would be significantly higher than that would allow institutions to bang for buck, get the marginal cost of this, which is what we're looking at with the in-state tuition, that it will be larger than just 110% of what the in-state tuition is. That's just a thought that I had. Thank you.
Okay.
Fair enough. And I'm going to give the author is a member of the committee. I'm going to give him the opportunity. Should we come back and at the appropriate time, if we have a move, if we wish to take action on this, I'll give him the opportunity of that, and we'll give you all the opportunity to debate the number. I did want to make a suggestion. I could have brought a substitute to this. I know there's strong feelings on this measure, both on both for and with some reservations. So I wanted this to be the bill we heard today, and even though there might be just this one change, I'm going to suggest that as we move forward on this bill that we make, I didn't want it to appear that when we get a sub out here and I tell you it's just one thing, unless you see it, you have to read the whole bill. I would suggest on line 17 and 18 that on line 17 we start after the word unit and strike that is designated a research university by the Board of Regents or any such unit. And I tell you why. That's not necessary because the language immediately following that says, in which the two most recent academic years did not meet all academically qualified applicants. That already takes care of those universities. So this would remove a statutory impediment to opportunity tuition being able to be offered at research universities. Should there ever become a time when they're not full, sitting here today in front of you, that's not likely to ever happen. But I don't think we should put the statutory, I don't think it's necessary to put the statutory impediment in. So in fact, it will have no impact on the operation of the gentleman's measure, but should there be a situation in the future that one could do, and I will give you a for instance. I believe when the Medical College of Georgia merged with Augusta, that entire entity is still a research university, is it not? Ms. Altman, is that correct? You can just nod if I'm correct. After that merger, is the entire entity down in Augusta College, Augusta University, is that considered a research, the entirety of that is considered a research university? And yet, a portion of that does have opportunities for students to go, correct? Yeah, so that, in this would, without removing this language, this would not allow some people to attend portions of the Augusta University. It clearly, in the medical college portion, it is fully subscribed, and it would not be available because of the language immediately following on lines 18. So I would suggest that if the committee wants to consider it, if we get back to there.
And I would just reiterate, it's real important for me to stress that this is about filling capacity and giving kids the opportunity with areas of capacity. So I would be fine with that measure as well, but I do think it's important to stress to folks that this is about schools with capacity.
Exactly, and that's what the chair is trying to do here is not inadvertently remove a school from consideration that does have capacity. We're going to go in reverse order this time. Representative Park.
Is that me?
Yes.
Thank you, Mr. Chairman. To the author, is it not true that setting specific or explicit parameters in the bill would both accomplish your intent of providing opportunity to students who've essentially gone to high school here, been born and raised in Georgia to a certain degree, and also provide our universities the flexibility given their relative capacities?
Yeah, I think that's a fair argument. Yes, that's right. I think, and I'm willing to talk with Representative Perkle about what does that factor need to be, but because I do think it's important to give the university system flexibility, but I also want to make sure that we're making a concerted effort to show folks that we want them to have opportunities to stay in Georgia and pay taxes in Georgia.
Thank you.
And I would strike the word born from your first comment.
Yes, sir.
That way we wouldn't be having this conversation. Sorry, couldn't help myself.
I think he was just speaking generally, not necessarily per se legally, but good case. Dr. Clark.
Thank you, Mr. Chair. I just want to clarify on lines 62 through 68 if the student, when they are eligible for this tuition, there is not going to be a huge fluctuation in their tuition from year to year. So the tuition will, I guess, quote, follow them as far as like they will. My concern is that a student comes in and they're eligible for, let's say, $5,000 tuition, but then the next year, maybe the USG changes the formula and we go a little bit closer to the 110 or whatever percentage we decide on.
Right.
Yeah,
So,
yes, ma'am.
Is that going to affect that student?
That's a great, and I don't want to interrupt the lady, but let me see if I can address your point, and if you have further questions to the author or myself. The idea behind that language is that if a student gets accepted and is in, that they would keep their factor for the 7 years. Now, that's not to say that their tuition couldn't increase, because if the tuition that the factor is multiplied against were to increase, theirs would increase just like other folks. But yes, ma'am, is that also the author's understanding?
Yeah, that's correct. So today, if it's, let's say the factor's 1.10, all right, 1.1, sorry. And next year tuition goes from $5,000 to $6,000. They would pay $6,600 instead of $5,500. But that rate would be consistent, would follow them for the 7 years. So yes, that's
and the 7 years came from the original term of the HOPE. That has been extended now. It's possible should this go into law, we could work with that as we do a longitudinal study on what it's taking. But the idea is, if this goes forward, to have people be more apt to be more of a full-time type student than for it to take that long. Isn't that true to the author?
That's correct.
Any other questions, online or in person? Yes, number 23. Is that the governor's floor leader, Representative Reeves?
Thank you, Mr. Chairman. And this isn't a question, but I just want to say to the author of this bill, thank you for working on this. It's taken a lot of courage, a lot of guts, and you've had a lot of very unfair insults and unfair, blatant lies that have been thrown at you. And this measure makes a tremendous amount of sense. And I just want to recognize the courage that I know that it has taken for you to bring this, and it means a lot, I think, to all of us, and it's inspiring. So thank you, Representative Carpenter.
And I thought I might not cry today. Golly, thank you, leader.
We're gonna move on, Representative. Anyone online? Anyone online? We're gonna move on to 291 at this point. 291.
Thank you, Chairman. Thanks, committee.
Dempsey.
Thank you, Mr. Chairman and members of the committee. So just to refresh, this is to offer an opportunities very, very important right now. The intent of the legislation.
Would the ladies suspend just a second? No, just I just want to make sure we have the right LC number.
490472S.
Yes, ma'am. Does everybody have that? Okay. Thank you. Please continue.
Certainly. The intent of the legislation is to draft a narrow targeted amendment to the tuition equalization grant program, the existing one, and address the healthcare workforce shortage in Georgia with the opportunity to expand the pool of quality nurses. So we've worked very hard to find the tight way. So if I could direct your attention, just to be brief here for you, and then answer any questions to the information that starts on line 53, really, is where it begins. And on 55, you'll see that it specifically says a baccalaureate degree program or programs in nursing, which is accredited by the Southern Association of Colleges and Schools or by the Higher Learning Commission, which is accredited by the Commission on Collegiate Nursing Education, which has a national council licensure examination for your average passage rate of at least 85%. And then, starting at the bottom of that, on line 67, this will be the new add, really, to this as well. Provided, however, that the only institution's baccalaureate degree program or programs in nursing shall be deemed an approved school for the purposes of this subpart. Therefore, the focus of this is nursing. It's very clear. It's not to add anything else, and it would allow them to participate with the 34 existing colleges and universities that students are available to get these grants from.
Thank you, and thank you to the lady for tightening that up to make sure that we are hitting the target that the lady's after. Are there any questions? Yes, ma'am.
Not a question. Thank you, Mr. Chairman. Not a question, just a comment. Isn't it true that we just had the opportunity to listen in the Women's Caucus about the dire situation of our nursing capacity, and this bill would help to help with that, and that we should take any step possible to get more nurses in Georgia in any way we can. Thank you.
I believe the lady, Representative Park.
Thank you, Mr. Speaker.
Don't go there.
Oh, I'm sorry. My mind's in different places. I apologize.
Speaker Ralston, I didn't put him up to that, I swear. Yes, sir.
To the author, just a question of clarification. How many private colleges or universities would be eligible under this bill?
Today, there are 34, and legislation was drafted to affect this, I believe in 2011. At that time, each of those colleges and universities were grandfathered in. As the existing law is written right now, basically in the code, it will allows those existing institutions, but it's almost impossible for anything new to get in. It was drawn very tightly, and so we want to add to the tightness on this one.
Thank you for your good work.
Dr. Clark.
Thank you, Mr. Chair, and thank you to the author for this bill. As you know, I'm a friend of nursing, so I do appreciate this legislation. I'm just curious. I know that currently there are 34 institutions that fall under this category, and this bill is meant to expand that. How many new programs will be eligible if this bill passes?
At this point, the only one I am aware of is Chamberlain University, the nursing program there.
Thank you.
That's the only one we're aware of, but if anybody else fits that strict criteria, in other words, if anybody else is, doing those things, has been doing them that long, has that type of results, this operating, it would allow them to create additional nurses for our state as well, correct?
That is correct.
Number 27, is that you, Representative Metz? Yes, ma'am.
You know what? If you could
get a little
let's do
closer.
that.
What about now?
That's better.
Okay. Thank you very much for bringing this bill forward. I'm just wondering, I noticed that accredited by the Southern Association of Colleges and Schools is mentioned several times in the bill. Have you considered other accrediting organizations which is very well recognized across the country?
What is the name of it? The name of the other organization is what?
Oh, I know there are 2 or 3 or maybe 4, but it just struck me because I'm just reading this and I saw it here twice, and I know there are other accrediting agencies. For example, even one of the private schools right here in the Atlanta University Center is being considered right now, but it's not with the Southern Association of Colleges and Schools, and that's why I thought of that.
Right. If you'll look at line 56 and 57, you'll see that there are 2 mentioned there, the Southern Association of Colleges and Schools or by the Higher Learning Commission.
Yeah, to Representative, I think if you have information about other accrediting agencies that we may need to look at, I'd be happy to do that. I think the ladies' work here is being done, or these are the ones that have been used to accredit other schools, and that's what we're staying with. But if you have that, would be something we'll look at in the interim. Thank you for bringing that up. Are there any further questions from Chairman Dempsey, Chair Lady Dempsey? Anything online that you see, Ms. George? Okay. All right. I'm gonna. I don't think we have a terribly controversial measure here. I'm going to present from the chair until we get to a place where we're in operation. This is House Bill 617. You did receive a substitute today. Normally, I'm going to ask you to later to take action. Normally, I wouldn't do that on a substitute, but I will say today that the only change in the bill from the bill you received last Wednesday and this substitute is we deleted section 2 that had an effective date of January 1st, 2022. So this will become effective by action of law or by the action of the governor's signature or in lieu thereof. This measure is toward the name, image, likeness for our student athletes. Basically, our ladies and gentlemen that play in post-secondary institutions, there's some conversation going around nationwide about how or shouldn't they be compensated for their name, image, and likeness. That is sure to be a national discussion and one that may find its way to administrative hearings or in the court. It is my information that many states are passing basically legislation such as this to provide for our athletes to be on an even feel, pardon the pun, an even bearing. So by passing this legislation, if, for instance, the NCAA doesn't like it and they may enter into an administrative hearing or perhaps even legal action toward pulling this all together, Georgia would have a seat at the table, and therefore our ladies and gentlemen that participate in post-secondary athletics in Georgia would have a seat at the table. Quickly, it covers lines 24 through 28 cover all of our post-secondary institutions as part of the definition. Line 42 through 44 is a safe harbor to make sure that this compensation these student athletes receive is not to get them to come to the institution, but after they're there. It provides in lines 45 and 46 that their scholarship should not be counted as part of that compensation. It makes public their agreement for their name, image, likeness compensation so that it can be coordinated with the schools and not in conflict. It gives notice in the post-secondary institution to disclose that their student athletes have a representative in lines 58 and through 63. It requires, this I think is very important and is quite frankly being done at most of our major institutions now, larger ones. It provides for education for our student athletes about the business practices related to their name, image, and likeness. It says who can't be the agent for them. And no one at the post-secondary educational institution, no one from an intercollegiate athletic program shall do that in 74 through 77. It basically says in lines 83 through 90 that an intercollegiate athletic association can't prevent our athletes from playing if they receive compensation. To be honest, that is the part that is sure to be discussed vigorously, perhaps challenged in court, but hopefully as states, for us to get on an even playing field and get our student athletes a place at the table by passing this, there will be a reasonable conversation to go on and a standard across the country so that this is good for the student athlete and doesn't morph into something that could be abused. So that's what we're trying to do in the legislation. Not many times, in fact, I can't think ever in my career here have I brought a bill that said to you, we need to move this, because failing to do so would put our student athletes at a strict disadvantage. But there may be work to be done before this finishes on March 31st on our day 40. But due to our timing, this was brought to us, and it is very necessary. I have confirmed with several I've gotten several legal opinions relative to this. This does no harm to the student athletes in Georgia as it is written. If we passed it as it is written, we would be aligned and in a good position. But I will also continue to endeavor and work with components of our university system, if they're allowed, if not, attorneys and experts in the field to draft this in a way that would most benefit our student athletes at all of our institutions. With that, I'll take questions from anyone. Number 23, Governor's Floor Leader.
Thank you, Mr. Chairman. I don't think that you said this. What is USG's position on this?
Well, I'm not going to put them in a position. I think their position is not to have a position because, again, this is a little bit difficult in that their institutions, and we have somebody from USG, I'll be glad to ask them, but I think our universities within our USG system and some of our private universities are part of the NCAA or NAIA, various intercollegiate athletic associations, and this is at some point it's going on in certain states, and so I don't know that they would necessarily advocate for a position that would be against something that their members, their membership, they're being required to do, if that makes sense. So there are rules that say athletes today are not supposed to be compensated for this. There are states that are acting and saying, yeah, they can anyway. It's coming to a point for a conversation. Without a bill in Georgia to allow our athletes to participate, we don't get to be part of that conversation to build a consensus that will be good for these student athletes. So we can go to the university system, but I think they would probably yield to the will of the legislature. Again, we're doing this with the best interest of the athletes. We're not picking a fight, is the best way I would say it. But sometimes we need to act this. It's been talked about for years. I don't know that I personally, if I can answer your question, I don't know that I personally think it's the greatest thing to happen to college sports. I'm not sure it is. But I also understand a lot of people make money off the name, image, and likeness of these athletes. And if they're going to be compensated, we need to put a process in place so it can be fair to them, but not put them in a position where they lose their college scholarship, where they lose the ability to play. And that's what this intends to do.
And may I ask one more question?
Absolutely.
This is very, very important, near, dear to me. Does this cover mascots?
Does this? I know you asked that
because
a bit.
Because I was a student athlete, a two-time letterman. So
I know the gentleman has had a bit to ingest, but it might well.
Good.
It might well include that Harry Dog or Buzz at our two larger institutions actually get compensated for that likeness. I don't know who owns the copyright to Buzz.
I think that this Georgia Tech does. So.
Well, sorry, Georgia Tech, not an individual. Yes, sir. All right.
Thank you, Mr. Chairman.
Yes, sir. Chairman Perkle.
Thank you, Mr. Chairman. On lines 50 and 57, so on lines 50, a student athlete should not enter a contract. Let's say they sign a contract with Puma. I reckon they still make shoes. And the school had not had a previous contract with another shoe manufacturer. And so line 3, or code 3 of line 57, says this post-secondary institution can assert a conflict under paragraph 1, which is the student is endorsing Puma. And so am I correct to say if the school has a contract with Adidas, that would prevent the student from signing a contract with Puma, but the reverse is not true. Is that correct?
The contract, I believe they're that's being referred to here is the contract that's really non-existent now between the student and the university. There is no, and again, I am many semesters shy of a law degree, but my understanding is that is contemplating that if and when this is worked out, again, if this is passed and the intercollegiate athletic associations come together with various states to work on this, that there may well be something like, in addition to your scholarship, you agree to work with the university on their contract and may even be compensated the same as everybody else, and you wouldn't enter anything that was in conflict with that. The contract that it contemplates here doesn't exist today because today it's illegal to do that, and it would render an athlete ineligible to have compensation. Does that make sense?
Yes, sir, it does. Thank you for the
So, but
clarification.
that's a
Yeah.
great question, and I
Thank you.
wish I had a better answer, but this
No,
is
that
a
was
bit.
good. I'm in support of the bill. Thank you.
Yeah, this is a bit uncharted territory. But we're just trying to put ourselves at the table so we can look after our student athletes. Representative Park.
Thank you, Mr. Chairman. So to Chairman Perkle's point on lines 50 to 52, I think some additional clarification may be helpful in the language, just because the way in which I read it, if a student athlete's team contract says a student or student athlete may not receive compensation.
I'm sorry, say again.
If a student athlete's team contract prohibits a student from entering into a contract for purposes of compensation for their use, image, likeness, would that not undermine the intent of the bill?
It would, and you know, I'm also, many have no experience in running a college athletic program or coaching one, but I think if this is agreed upon and somehow worked through the NCAA, I think it would be hard for universities to do that and recruit athletes. I mean, it creates a level playing field. So you know, specifically, your answer would be yes. It would go in conflict with the bill. In reality, I don't see that would ever take place. For if you were doing that, you would probably have a very empty collegiate athletic team.
So if I may, just to rephrase that question, would this provision, again, lines 50 to 52, allow a university to essentially refuse to allow a student to enter into a contract, or is that not the case?
As a practical matter, I don't think the legal, I think Chairman Reeves, I think are you not an attorney as well, Representative? Or no? Representative Parker?
Yes.
Yes, you and Representative Reeves have much more of a legal mind to that. But I think since this is contemplating an agreement that is not yet in place, I think there's a lot of puzzle pieces that go together. That's why I said this is the first time in my years down here I'm asking us to move forward on legislation that I'm sure will evolve in the next couple of weeks. And a positive that when this creates the administrative hearings or the legal discussion, that after that goes into place, I'm positive we would be coming back to do this. This, if you will, is the foundation for a building on which our student athletes can be compensated for their name, image, likeness. It's nothing more than a foundation, but without the foundation, they don't have an opportunity to be part of that process. But that's a great question, and you know, perhaps you can help us get there. Thank you. Dr. Clark.
Thank you, Mr. Chair. So I understand the intent of this bill. I understand that we want to, make sure that when we are basically using student athletes as, advertisement and other things, that they should be able to be compensated for that. I think my concern is when we're talking about obtaining representation and student athletes coming into college with agents and things like that. I think we are getting into some muddy waters there. And so to Chairman Perkle's point, I went to the University of Tennessee. They had a contract with Adidas. If I, as a high school senior, was just this amazing track star and Nike wanted to represent me, then does this create a conflict when University of Tennessee now tells me, well, you cannot wear your Nike gear because we have a contract with Adidas? And therefore, would they be in violation by denying me access to the program because I'm represented already? I just think the representation part just concerns me when we're talking about children and things. So I think people should be compensated, but I'm just a little bit worried about all these contracts and stuff floating around and the conflicts that can be born from that.
And I appreciate the lady's question, and I will try to answer it as best I can. I am familiar with universities that have contracts with, I mean, I don't know, we want to give people free advertisements here. But we've used them all, from Puma to Nike to Adidas to, there are others. We shouldn't leave Under Armour out either, so we'll just put them out there. I'm familiar where universities have contracts with people that make gloves for baseball. And there's somebody that pitches that wishes to wear a glove of a different make. And what they actually require that to do now is you have to brown or black it out so that you can wear the glove you need to wear, but when you're pitching, the logo doesn't show. You'll see some things like that go on with some of our other athletes. They recover that. You'll see NBA games that if you're a team this, then you want to wear that kind of shoe because you perform better in it, or you're in the NFL and you perform better in it. You just have to color that out. So to answer your question, I think if you do have that representation, again, this lays out how they hope to manage that. I think when we build that foundation, when they go and have the administrative hearings or a legal process to come by doing this, once that's implemented, more than likely, I hope there's a nationwide format of how to do this, and then we would adapt our law to codify that, because I think there are people that will be more in the know about how to put that together. And all of our coaches, and all 99.9% of our coaches and administrators in intercollegiate sports are there for the student athlete, and they're going to try to support them. And so when that goes in, they're going to come up with a true plan. This gets us started, and then we'll codify that to make sure our student athletes are protected. Representative Wiedauer.
Thank you, Mr. Chairman. If I might, two quick comments to Representative Park's question. I believe, if I'm reading this correctly, your question might be answered in lines 60 through 64, where they would not be able to adopt something that would prevent an athlete from engaging in that kind of a contract. I may be wrong, but look, I saw that and thought I'd draw your eye to it. Beyond that, obviously this is a slippery slope, Mr. Chairman. As you know, I'm very involved in collegiate athletics. I myself, letterman in Georgia. Very concerned about how this reshapes collegiate athletics across the nation, but certainly understand that we have to have a seat at the table in the conversation. And I appreciate you bringing the measure, and look forward to kind of massaging it to hopefully.
Thank you, Representative. Yeah, and to be clear, I have the same worries about what it might do to intercollegiate sports, but I hope by Georgia having a seat at the table, by a number of states, the conversation is going on piecemeal all over the place. By doing this as a state, we become part of a process to get to a good, move toward a good conclusion, and hopefully minds that are thinking together will do that. So that is the proposal. Do we have any questions online? I want to thank also the co-sponsors, of the measure, Trey Rhodes, Representative Fleming, and the Dean of the House, Calvin Smyrie. We all, I think, probably share the same reservation, Representative Wiedauer, is we want to see our college athletics continue and the student athletes thrive. But we believe that, if people are going to be compensated for their name, image, and likeness, that we want Georgia athletes to do that. So we'll get back to that, and I'm going to ask the committee's favorable consideration so that we can move that forward and keep Georgia on that. With that, I'm going to take we're going to take just like 1 minute here. I'm going to call, actually I'll ask Ms. George, can you call the roll so we can just get folks here, and that'll serve as the ringing of the bell in the House, that if folks are online or a bit away or trying to get here, we're about to go back and call the bells and try to see what the pleasure of the committee is relative to these items. Ms. George.
Representative Earhart. Representative Bentley.
Yes, Patty Bentley's here.
Representative Burnell. Representative
Hello?
Carpenter. Yep.
Did you call Burnell?
Yes, ma'am.
Yes,
Representative Carpenter. Representative Clark. Representative Dempsey. Representative Dickey.
Yep.
Representative Dreyer,
Here.
Representative Dubnik,
Here.
Representative Holcomb, Representative Holland. Here. Representative Jaspers,
Here.
Representative Kausche. Representative Kelly, Representative Knight, Representative Mathiak. Representative Metz. Representative Park. Representative Perkle. Representative Reeves. Representative Smyrie.
Here.
Representative Washburn. Representative Wiedauer. Representative Williams.
Here.
Okay, ladies and gentlemen, we are going to go back and call the items. We'll just call them in the way they are on the sheet here. We have House Bill 1 by Representative Bonner. LC 490477S. We've had several hearings on this. We had discussion earlier today. What's the pleasure of the committee relative to HB 1? I have a motion, do pass, and a second. Is there discussion on the motion? Discussion? I'm looking online, guys, so if wave, turn something off. Discussion? Discussion? All right. I'm just going to say, all those in favor say aye, or raise your right hand. We're going to count. If we need to do something different, we'll go past that. You know, can you help count? Yeah. Well, you know what? This is not working because people in the room aren't seeing the people online, so that's not working. I'm sorry, guys. We're going to have to online. We're going to have to because I'm looking at your hands being up, but for us to be visual here to people, we're going to have to just call. So we're going to call the roll. We're going to call the roll for this. We have a motion do pass on HB 1. Ms. George is going to call the roll. You're member 1, right?
Representative Earhart. Yes. Representative Bentley.
No.
Representative Burnell.
No.
Representative Carpenter. Yes. Representative Clark. No. Representative Dempsey. Yes. Representative Dickey. Yes. Representative Dreyer.
No.
Representative Dubnik.
Yes.
Representative Holland.
No.
Representative Jaspers. Representative Jaspers.
You're on mute, Representative. We can come back to
Representative Kausche. Representative Mathiak. Representative Metz. I'm sorry, I didn't hear you. Representative Park. Representative Perkle. Yes. Representative Reeves. Yes. Representative Smyrie. Representative Washburn. Yes. Representative Wiedauer. Yes. Representative Williams.
Yes. Mr. Chairman, this is Rick Jaspers. I think I was not off mute yet. I'm a yes.
Representative Smyrie.
No.
Sorry, the motion passes 11 for, 7 opposed. It moves on to rules. Next item we have before us this afternoon, House Bill 7. House Bill 7 is traveling with its original LC 490254. What's the pleasure of the committee on on House Bill 7, LC 490254? Have a motion and a second. The item do pass. Is there discussion? Discussion?
Call the question.
Any discussion? Oh, I'm sorry. Yes, ma'am.
All right, thank you, Mr. Chairman. I just wanted to confirm, I thought we discussed earlier that you do feel confident that the language as addressed, or the clarification on the list of perhaps these individuals providing an affidavit, that can be addressed. One intention was I was going to move to amend the bill to remove move to amend line, I'm so sorry. Yes, thank you.
Right. The line that you were discussing, Representative Earhart, was line 70.
Yes, thank you, line 70.
I would, we're in discussion, so I mean, now would be the time for that amendment. Suggestion, again, I had from Legislative Council that it could be, it's the ladies, it's the ladies' pleasure. You're recognized, so you can make your amendment as you wish. I have language that would change that as suggested as well. So I'll entertain the ladies' motion at this time.
I'd like you to amend line 70 to add to read such other professional as deemed appropriate. I believe your language, Mr. Chairman, was by USG. Thank you.
If the lady allows, I will second her sounding of the amendment and see if there's a second. I believe on line 70, after professional, she wishes to insert comma as deemed appropriate by the post-secondary educational institution. I have a motion and a second to amend that, to make that amendment. Is there objection? Is there objection to the amendment?
I have a question.
Yes, sir. We'll do that. Yes, sir. Dean, what do you have?
I thought we were going to do it at the discretion of the University System of Georgia. You're saying it's going to be by each individual institution?
Well, that's a good point, Chairman Smyrie. I think in reality, they're probably getting their marching orders from the university system. Because I don't know the university system office would be on the ground to make that. Are you, is it something that you and you and
I've never seen us. As a former chairman of the committee, I've never seen a bill where we gave the discretionary power statutorily to the universities, to the institutions. I thought we always went through the university system rather than giving discretionary power to universities or colleges. Yeah. That means that that each institution can have a different kind of policy. The university system is fine with it. I'm fine with it. I'm just.
Dean, you've been here a long time, and I appreciate yours. I'm going to ask the lady if she minds amending that. So, and I'm probably a bit out of process here. So, I would offer this as a friendly amendment to the amendment that the amendment be amended to read as deemed appropriate by the university system. Let me back that up, Mr. Chairman Smyrie. I think the reason that the attorney suggested by the appropriate post-secondary educational institution is that this definition is used here for USG It's also referred to in the TCSG code, and I'm not sure that we want to use the TCSG code. Chairman Smyer, would you be comfortable that would you be comfortable if we move through like this, and then you and I check with Legislative Council and make sure that we're doing the right thing, and we can do a rule substitute together if we need to?
That'll work.
Thank you very much. Thank you very much, Dean. That's a good call. So we are on the original, or I will ask again, we have an amendment, just to be clear on that, since I muddied the water a bit. After professional on line 70, comma, as deemed appropriate by the post-secondary educational institution. Is there objection to the amendment? Any objection? Objection online or in person? I see none. The amendment is adopted. We're now back to the main question. The main question is we have as a do pass recommendation on LC 490254 as amended. Any discussion on the main question? Main question. Hearing none, I think we may have more of a meetings in mind on this. If there's not objection, I'm going to go with a voice vote here. If we need to have a divided vote, we will do so. All those in favor say aye.
Aye. Aye.
Any opposed? The chair is going to call that vote. Is there a no? Chair is going to call that unanimous if there's not objection. I hear none. You are on to rules, Ms. Representative Scott. We're now moving on to House Bill 120, LC 490461S. We've had discussion on this. We talked about it a little bit earlier. The gentleman made his presentation. What's the pleasure of the committee? LC 490461S. I have a motion and a second. This item do pass. Under discussion, we would take amendments. Is there any discussion? Yes, sir.
Yes, sir, Chairman. I would like to submit the language that I handed you about setting the cap at 110. So offering tuition between 100 to 110%. On lines 46 and on lines, trying to get there, sorry guys, 116.
If the gentleman doesn't object, I'm going to read this back as you handed it to me. The gentleman would like we're going to have to work on your drafting of an amendment, sir.
Sorry.
That's all right. So after the first instance of, there's only one. After percent on line 46, the gentleman would like to insert or more than 110%. So now line 46 would read that the opportunity tuition shall not be less than 100% or more than 110% of such eligible units. That would be how line 46 reads. That's the gentleman's motion. Is there a second? We're gonna handle them. You want to do them both at the same time, Representative?
No, that's fine. We can do them separate. I don't have a problem with that. I was just going to tell the committee there's actually another place in here as well that it needs to. So it'd be the same language would be implanted around line 68 as well. Sorry, and then you would also see it at 116.
Okay, so gentleman wishes to do this all in one amendment. So on line 68, after percent, it would be or more than 110%. I'm going to not read the whole line as it would be now unless somebody needs me to do that. Then we would go back on line
68.
That was 68, yeah. So on 9. Yes, 104, because the numbers don't match since you have the bill drifted with that. So on line 104, after percent or more than 110%. And on line 116, after percent or more than 110%.
That's
Okay.
correct.
So is everyone clear on those? It's a single operation, if you will, but it's needed in 4 places of the bill. So we had a move and a second on that amendment, which is in 4 places in the bill. Is there discussion on the amendment? Is there discussion? Discussion on the amendment? If not, we'll call a roll on this one. Well, let me ask, is there objection to the amendment? Anyone object? Any objection to the amendment? Hearing none, the amendment is adopted. Gentlemen, have further amendments?
I do believe you had mentioned an information about the designated research university on line 18. Removing that to basically say that we would restrict this to universities with capacity. So it would basically just eliminate the line. It would say any such unit.
Let me try for you.
Yeah, you try. Go ahead.
This is what was mentioned earlier and really has no operation today, but could in the future. So I believe the gentleman is moving to delete after the word unit that is designated a research university by the Board of Regents or any such unit. So the new text would read, starting on line 17, all units of the University System of Georgia, except any unit which, for the 2 most recent academic years. Is that the gentleman's amendment?
Yes, sir. Did not admit all academically qualified applicants. Yes, sir. So that just.
Is there a second? I have a motion and a second for that amendment. Is there objection to that amendment? Is there objection? Okay. Now would be, sure, absolutely. Pressure number 5. Yes, ma'am.
I'm confused. To me, it reads now as if we were eliminating those with capacity, and that's not what we want to do, right?
No, but, I understand the lady's question. Let me try to take care of it. It is eliminating an exclusion because this is defining what an eligible unit is. It says it means a unit of the university which shall include all units except. Okay, so if it would include all the units in the university, reading as it is now, except those designated as a research. Okay, if we strike that, it would include all units of the university except any such unit which for the 2 most recent academic years did not admit all academically qualified units. Applicants. It's a bit of the definition is using it's using exclusions, so we're eliminating an exclusion. Should this amendment go forward, this would allow opportunity tuition where there are vacancies, where they have not turned away applicants, which, by the way, is what the university system rules require today. So if this amendment passes, we will be mirroring in code exactly what the practice of the university system is today. I see Ms. Altman nodding her head. So you would be past that. So that is the amendment. Again, discussion or if there's objection, if we wish to vote on the amendment, I'm happy to do that. Is there objection? Do you withdraw your objection, Representative? that noted that the representative's objection was withdrawn. They're hearing no objection online. That is also adopted. Now you have before you LC 490661. We've two amendments which affected the bill in 5 places. Everybody clear on the measure as amended? Any questions? This is discussion on the main motion, the bill as amended. It will be processed then as a, should it pass as a sub. All right, I'm going to go and ask Ms. George to call the roll. All those in favor, or she's going to call the roll. Sounds your preference. The motion is do pass as amended.
Representative Earhart? No. Representative Bentley?
Yes.
Representative Burnell?
Yes.
Representative Carpenter?
Yep.
Representative Clark? Yes. Representative Dempsey? Yes. Representative Dickey?
Yes.
Representative Dreyer?
Yes.
Representative Dubnik?
No.
Representative Holland?
Yes.
Representative Jaspers?
No.
Representative Kausche?
Yes.
Representative Mathiak? No. Representative Metz? Yes. Representative Park? Yes. Representative Perkel? Representative Reeves? Yes. Representative Smyrie?
Yes.
Representative Washburn? Yes. Representative Wiedauer? Representative Williams?
Yeah.
Representative Williams, can you sound your preference?
Yes.
Yeah. Representative Wiedauer?
HB 120 as amended, we'll move on to rules by substitute. We'll roll those amendments in and we'll go to substitute. HB 120 LC 490416S as amended by substitute. Mr. Walker, to our attorney, if I'll get with you and make sure we are clear on the amendments, but I think you have them, yes, sir?
Yes, sir, I'm keeping track.
Thank you. That moves forward to rules.
Thank you, committee.
HB 291, Chairman Dempsey. We had a presentation. This is to extend the grants to make more nurses, make it easier for people to become nurses. What's the pleasure of city council? God, you can tell I used to be a mayor. What's the pleasure of the committee? It's past 2 o'clock. What's the pleasure of the committee in regards to HB 291? My apologies to you all. I have a motion do pass on House Bill 291. Is there discussion? Is there discussion? Oh, I thought I had one. I heard a second. I failed to say there was one. I heard several. There was a motion and a second on House Bill 291. Is there discussion? Discussion. I was back off reminiscing about city council days when I was asking. Is there discussion? Should we voice vote them all?
Yeah. Courtney, what the vote was, we didn't say.
I'm going to go here. All those in favor say aye. Aye. Any opposed, no?
Aye.
I had one.
Aye from Patty Bentley.
Now I'm confused. Representative Burnell, are you a aye? Are you a yes?
Yes.
Representative Bentley.
Yes, from Patty Bentley.
Yes, ma'am. All right, you move on to rules. I detected no votes. Am I correct? That moves on to rules. I'm going to let you call the vote here on this. I'm going to yield over to the vice chairman of the committee and ask her to handle 617.
Okay. And do I have a, what is the pleasure of the committee on HB 617? Do I have a second? Okay. Any discussion? Questions? Yeah. I think we're going to do shall we do a roll call as well? Okay. Okay, all right. All right. All those in favor of the passage? All those in favor of the passage of HB 617, please signify by saying aye.
Aye.
All those opposed, like? Okay. Hearing no objections.
Aye from Patty Bentley.
Okay. Thank you, Representative Bentley. Hearing no objection, I'm sorry.
If you don't mind, I felt it's just, that was by that was the committee sub that struck the effective date, so it'll be effective on the governor's signature or otherwise operational law.
Yes. Okay. So, do I need to vote again? No, we're good. Okay. So, having heard no objection, this motion does pass. HB 617.
Okay. Thank you very much. Members of the committee, thank you very much. We will meet again somewhere after crossover day. Probably not unless there's something that we see with one of these measures that got to rules and they recommit it back to us to do that. But I want to thank everybody. These are thoughtful measures that we had, sometimes a bit controversial. I appreciate everybody's thought and input on that. It's very vital to Georgia, and I will argue with Chairman England and Chairman Smith and probably get in trouble doing so, but I think we have the best committee in the House, and I appreciate you all. Without objection, if there's no further business before the committee, we'll stand adjourned. Without objection, we are adjourned.